Welcome to Winston and Strawn's Healthcare and Life Sciences 2022 Summit. Let me start with the introductions. My name is Sarah Susnier. I'm a corporate partner at Winston and Strawn based in Paris. I'm barred in the US as well as Paris, France. I assist clients with domestic and cross-border transactions, especially in regulated sectors like tech, fintech, media, and healthcare and life sciences. I have a particular expertise in data privacy and security, and this is what brings us here today. I'm joined by Lorraine Petit, who is my associate, educated both in the US and in France. She focuses her practice on corporate advisory work in regulated sectors. During our exciting session on data privacy and security, we'll be touching up on a variety of issues, including recent trends in data privacy and security in the EU and the US, as well as treatment of healthcare data and treatment of data and security in M&A transactions. To cover all these issues in a short amount of time, we have two overqualified speakers from Platform.sh. Let me start off by introducing you to Joey Stanford, VP of Security and Privacy at Platform.sh, specialist in IT and compliance for over 2 decades. Joey holds a computer science degree from Marist College and has studied in the United States at Air Force University. He is joined by Erika Bustamante, Data Privacy Counsel and Manager of the Platform team at Platform.sh, of the Privacy team at Platform.sh. She holds a Juris Doctorate at University of Houston and a bachelor's at University of Texas, Austin. Joey and Erika both work at Platform.sh, French tech company created in 2010, now with over 300 employees worldwide. Platform.sh is fully remote with a presence in France, UK, Germany, Canada, Australia, and India, to name a few. Platform.sh builds, runs, and scales your applications end to end. Now to get to our topic. It's been an interesting year in both EU and US when it comes to data privacy and security. In the US, data breaches in 2021 have reached an all-time high. The numbers reflect a year of high-profile cyber attacks that target everything from the country's largest oil pipelines to companies entrusted with the personal information of millions of American consumers. In the EU, the numbers are equally worrisome. CNBC recently reported the fines for violations of the European Union landmark privacy law, known as GDPR, have soared 7-fold in the past year. EU data protection authorities have handed out a total of 1.25 billion fines over breaches in GDPR since January 28, 2021. That's up from 180 million. That's up from about 180 million a year earlier. Notification of data breaches from firms to regulators has climbed by 8% to approximately 356 a day on average in the EU. We'll discuss these numbers down the line and the differences between the US and the EU laws in the next couple of minutes. But for the time being, Joey, what do you make of these increases in data breaches across the board? And what do you think about the EU fines?
Well, it's interesting, and I think this is the direction we're going to continue to see, certainly. And the EU fines are just the beginning. We've seen indications from entities around the world, governmental entities around the world, where they're getting more serious about this topics. Even strangely, in the United States, which typically has a reputation for not really caring about privacy. We've seen targeted attacks, like we've seen like the Ukraine conflict as an example, ransomware, vulnerabilities and software dependency, such as Log4j. It's kind of some of this stuff is really kind of troublesome. Like even ransomware, if we just pull out a statistic, ransomware used to take about 5 days from the time that you were infected back in 2020. It's now 6 minutes to do that. So we're going to see this sort of continue to increase. We're going to see the attacks increase. We're going to see the fines naturally increase from that. And that puts pressure on businesses in order to begin to secure their attack surfaces and then hopefully spend additional money on the necessary resources, whether it's internal personnel or external vendors.
Erika, what do you think?
Yeah, I totally agree with Joey. And I think pretty simply, the pandemic, I think, has been a huge cause of an increase in seeing these types of breaches and fines. Just at a basic level, there's an increase in work from home across the world, that just means a general increase in online activity. So everything from virtual doctor's appointments to online grocery shopping, that's going to mean an increase in the amount of personal information that individuals are just putting out there. So as we see technology advancing and all these new offerings of what you can do online, making your life more convenient as you work from home, companies are having to essentially keep up and really pay attention to now how they're handling that data. And so I think, yes, the challenge is balancing that with the increase in laws, whether it's the passage of new regulation or just amendments to already existing laws that are trying to keep up with the technology that it's advancing. This requires time and resources to implement, and that's especially hard to do for some smaller companies and even for some bigger companies that haven't had a dedicated privacy program before the pandemic.
Okay, I think I'll go on from that question, Erika, and I'm gonna throw a loaded question for you. But what kind of companies and information do you think are particularly vulnerable? And do you and your teams handle healthcare data? And if yes, what kind and how?
Yeah, so picking back off what I said, I think companies that don't have a dedicated privacy and security team are going to be the most vulnerable. And I think that's because without having the proper subject matter expertise in those fields, the company likely hasn't really thought out how to implement data protection and security requirements. Maybe they're saying, okay, this law exists, but without having the team to actually implement how you comply with those requirements, and then also constantly monitoring their practices for compliance and improvements. On top of that, they're going to be vulnerable. And this is usually smaller companies. On the other hand, international companies, even large ones, they can also be vulnerable if they don't have a consistent approach to data protection in place. As for types of information, I think typically health data and financial data are the most targeted, but really anything that can provide value to an attacker. So think credit card numbers, social security, driver's license number, etc. And for us, Platform doesn't itself use PHI. However, we do have customers that want to run healthcare workloads on Platform. And so these customers, they themselves are responsible for managing their health data. But since we're hosting their applications, we have to ensure that our infrastructure is protected against, any unauthorized intrusion. And we don't know exactly what data elements specifically they're collecting from their end users. We just know that it is classified as health data on our systems. And so what we do is we give it a HIPAA tag in accounts so that we can ensure, okay, we know this customer is storing health data, so we need to treat it accordingly.
What about you, Joey?
How do I follow with that? Erika did a wonderful job. I agree with her. I mean, traditionally it's been finance, healthcare, social media, and governmental data. Why of those? Same reasons Erika just meant, because there's lots of really good, juicy data in there that I could use to, steal credit cards. I can impersonate people, get car loans, get house loans. So any businesses really that really have these large data warehouses of personal data, they have traditionally been the biggest targets. What we're seeing though is beginning to see a little shift in that. There's still big targets there. But the shift we're seeing is around businesses now that deal with authentication, like user authentication management, such as Okta. In fact, Okta was in the news just a couple of weeks ago because they had a breach in January for this. The same thing with password managers that we all encourage everyone to use, LastPass, Bitward, and LastPass has had several incidents over the last few years about that. And the reason for that is simple, because if you penetrate those applications, you now have the keys to the kingdom. No matter how many firewalls and everything else you put up to protect the data and how you classify the data, it doesn't matter if I have your account and I can log in. And so that's sort of where we're seeing an increased target. Now, there's another piece that's very popular in France, and that's another emerging area, and that's AI. It's actually popular everywhere else, but at least the CNIL has been more interested in providing some documentation for that. And so we've seen some basic elements of attacks on how the substrate of AI, as well as specifically like poisoning attacks. So when AI is learning how to do something, we can poison it by giving it some false information, which will then make it vulnerable to attacks later down the line. So it's all really interesting, and there seems to be like something new happening every day, which is very interesting for a security person, but very terrifying if you're trying to protect and protect your data, protect our data, protect the employees' data, protect your customers' data.
And following up in this issue, and without, of course, giving us your magic formula, Joey, how do you approach the topic of data breaches at Platform.sh? What kind of data breaches in general have you seen from companies in your perimeter?
Yeah, this is actually really interesting for me, and the reason is we're a hosting company, a platform as a service. So we have multiple customers, thousands of customers, and so naturally those customers will have exposures. And so what do those exposures look like? Well, we can boil them down into a small number of groups. The primary one is what I call application security. It's I have an application, and you have developers that create that application, and they don't routinely update their application, or they don't update the infrastructure that it lies on. So they don't update the operating system, or they don't use secure coding practices. What we've seen, so it's application patching, infrastructure patching, but sort of the biggest trend these days is something that's called software dependency management. So as you build an application, your application is based on reuses a number of libraries, mostly open source these days. And as you look at that, each of these open source packages that you use other open source packages, which use other packages. And so you have this big dependency tree. And so how do you go about understanding if there's a vulnerability down here? Did this package 5 layers down, has that been patched? How does it affect the one that's 3 layers down? And so we get into this concept of software bill of materials. So if I'm going to buy a piece of software, I'm going to make a piece of software, what are all the components that go into that? And there's a couple pieces to this too. There's the piece that I know Erika loves to talk about, which is what's the licensing behind all of these items. But purely from a security point of view, there's the how do you keep up with all the patches? And we've seen, additionally, we've seen things like the Log4j incident is a good example of this, right? So Log4j was included in several downstream packages, so everyone had to go audit their code and the software dependencies they're using. And it's very difficult with software dependencies because we don't have a mature tooling to help us with this. We have some tooling, it's in its infancy, but we can't really get into this and look. So that's one whole section of application security. And that there's really another component to this, which we don't see as much, but we hear about it a lot, and that is endpoint security. And that would be your workstations, your computers, your laptops, and are they patched? Are you running some sort of antivirus, anti-malware, something that's on behavioral analysis scanning, so that you can be detected? Because earlier I mentioned that ransomware, which typically affects both servers and endpoints, you've gone from 5 days from like 2020 down to 6 minutes now of being affected, and so you need to have something that protects that. There's this third bucket, which is what I call just poor configuration management. And that's, you see this in the news all the time, especially in the United States. Somebody goes out to Amazon, they have an S3 bucket, and they've left it unsecured, and now you've got hundreds of thousands of health records that have now been exposed because somebody just wasn't paying attention, they weren't following good security hygiene.
And Erika, what do you think about that?
Yeah, so obviously, as you can see, Joey's kind of the expert when it comes to the technical nature of what we can see from security incidents happening. I really step in from a legal point of view. So when worse comes to worse and a security incident has occurred, the next step, how we handle that is determining whether that security incident involves any PII, so personal identifiable information. So really looking at, for us, we have a data breach policy, and that outlines our general data breach procedure. As a company, as a global company, we take the stance on complying with the strictest data protection law out there. So currently, that's the GDPR for us. This way, we can create like an overall consistent procedure for responding to and investigating these data breaches when they do happen. And then we can supplement that with specific notification rules, specific requirements for individual countries that may have different requirements in their jurisdictions, data protection law. But yeah, so that's kind of how we handle when something does go wrong. We have a consistent procedure we follow with that we just make updates depending on the situation.
So let me also bring your attention to another point in the US, especially notification requirements. So as you know, this requirement could be triggered if there have been a breach of personal information. But the thing is, the definition itself of breach differs, by states, and notifications are also required if a certain risk of harm threshold have been met. And in both, issues, definition, and also risk of harm threshold, we see that there is no, or at least minimum guidance, there is no case law. And on the other hand, in the EU, with the GDPR, we see that breach notification requirements are more harmonized. And unlike in the US, data protection regulators in the EU have provided some extensive guidance on these issues, which makes clear that companies need to have a broad conception of what qualifies as a reportable breach. So who do you think has a better approach and why? I'll let Erika first on the issue.
Sure. So I think having more guidance on what qualifies as a data breach is the better approach. So probably as you mentioned, in this case, the EU. I think people are probably split, right? Because while some might think that having minimal guidance is good for the company who experiences an incident, and then they can take a sort of defensive approach and argue that such incident, doesn't qualify as a data breach or doesn't fall under the definition. I think it's actually harder to do that with a lack of guidance because there's little to base your arguments off of. So you can't point to guidance and examples that shows that something was considered a data breach and, compare your situation to that and say, no, look, it's much different than this. In that case, you had a massive level of data. In our case, it's minimal data. And so I think the good thing about a law like the GDPR is you kind of get the best of both worlds. So there's plenty of examples of what is considered a breach. So it does make it easier and quicker to identify whether you're dealing with a breach soon after the incident occurs. But then you also do have some flexibility when it comes to notification. So for example, notification to a supervisory authority is only required if the personal breach is likely to result in a risk to the rights and freedoms of data subjects. And similarly, notification then to the data subject is the same, but high risk instead of risk. And then further, it's not required, notification is not required if certain elements are met. So the GDPR gives a list such as, the controller has taken subsequent measures to make sure that that high risk is no longer going to, or is not likely to materialize. So maybe they've addressed this breach immediately. Maybe, they've taken something down. So you get to make a decision there on impact and risk of the breach when it comes to notification. And there also are examples out there, guidance out there on risk that you can refer to in comparison. So I think it definitely, having more guidance can be beneficial. Also, there's guidance for GDPR on what you need to include in a notification. So if you ever do have to make that notification, whether it's to a supervisory authority or data subject, there's a list of items you have to disclose and include in that template. So it allows you to be prepared ahead of time and, sort of create that template that you can use, and exactly what you need to do if that situation does arise.
And Joey, do you agree with this analysis about guidance?
Yeah, so this is interesting. I love what Erika said. I think it's spot on. And I also support the EU model. mostly for me because it helps map to the confidentiality, integrity, and availability that we talked about earlier, right? That kind of helps define exactly what a breach is. So you can do, it's very simple for businesses then to basically make a flow chart or a checklist. Is it this? Okay, it is. This is what we have to do next. That does cause problems, as Erika said, right? Because sometimes you're like, a business doesn't want to do this. They don't want to disclose it. They're afraid of it. Maybe they're going to go for investments. And if it classifies this as a breach, they're going to, it's going to be a black mark when they go to talk to investors. Or if a company is going to be bought through an M&A, same sort of situation, right? There's more risk that's added to that. So it absolutely has business impacts. It has impacts on your financial insurance as well. But the reason I like it, Erika had mentioned to it too, like this is the transparency part. So when the breach notifications, we talk to people, but it also encourages more transparency. So it forces you to do something, so it increases your transparency outward. But I think the real benefit, or a real benefit, is simply that it makes businesses take data security and data privacy seriously. Privacy by design, security by design, having a security team, doing things you need to, and then standing up a process to deal with this so they're not caught flat-footed when something happens. And that's where, if we traditionally look at fines in the United States and a subset of the fines in Europe and a subset of the fines in the UK, because remember the UK is GDPR compliant, even though they're now separate. We begin to see the same sort of thing where people just haven't spent time on protecting your data, my data. And so how do we trust them if we haven't? And so this is the other advantage to doing this. As you build this up, you begin to develop, use it for marketing teams. Love this. Okay, great. We now have this security thing. We now take this data privacy. We're GDPR compliant. We're HIPAA compliant. We're Pipetta compliant. And now you were starting to, as a company, we start to begin to develop trust with our users. But it's not just our users. It's our employees. Everyone always thinks about GDPR is in place to protect your house number and like PCI, your credit card number. But it's also about your employees. And how do you have trust? Like if you have employees, if your employees trust you as a business, they're more than likely going to continue to stay with you. Same with your customers as well. So it's not just check a box.
Yes, makes sense. And following up our discussion actually on the data breach, let's move on to having a potential breach. So I realized that you have not had one, but how, if you have one, how would you internally approach where it occurs, and to what extent would you have forensic investigators involved, or outside parties and vendors besides legal counsel? What do you think is the key in the potential data breach investigation? So maybe I'll let Joey answer first.
One's actually a pretty straightforward answer. And the first key thing is that you actually have a breach process. You have an incident management process, a security process, and a breach process. You'd be surprised at how many people I talk with, how many companies that don't have that. And it seems like it's operating 101. And maybe it's because all of us here care about this stuff. We were like, yeah, I can't imagine somebody that wouldn't have it. So like for us, we have, just like that, we have an incident process, a security process, a security incident process, separate from an incident, and then a breach process. And so we've defined, Erika's team has defined all this material. We've got templates ready to go. We've got a list of what's considered to be PII. Who do we have to notify? What has to be included? What are the timeframes? When do the clocks start ticking? So it's really this good hygiene, good discipline around incident management that takes you to the breach part. And naturally, when you get to something that's a major security incident and certainly a breach, you're going to be talking to all of the executive members in the company pretty much, right? Because they're going to need to know about it, because goodness, if I'm in Europe and I have to report to the CNIL or have to report to the ICO or some other supervisory authority, that's a big step, because suddenly you're raising your hand going, I had a data breach, come audit me, come look closer, put me under the microscope, and nobody wants that. And so for us, we just use all hands on deck, and we figure out if it's an incident, if it's a security incident, we bring in a security team. If it looks like it's going to be a breach, and we get a little scared, it's all hands on deck. Get everybody out here. Let's get the executive committee out. Let's get the security team. Let's get the operations team, the developers. We do everything because it would be detrimental for ourselves. We would feel bad because I challenge the company to say that we're not a platform as a service. We are a security company that it just happens to operate a PaaS, right? And so it's a mindset, it's a cultural change, and it's very difficult, especially in startups and actually, I guess, in all companies really, is to change that way of thinking to become more oriented toward data privacy, oriented toward data security. So what happens after you have a breach? Well, if all of you on the call here are lawyers, you've all read contracts, and in almost all of the contracts that I've read in the last several years, there is a right to audit if you have a security breach. And so it doesn't say that it's just the client that has the right to audit. It's the client, and they can bring in a third-party forensics investigator or whatnot. And so now, as soon as you have a data breach, those audit clauses can trigger. You now have the one or multiple clients who are affected. Even those that aren't affected can trigger their audit clause, right? And so now you have all this additional scrutiny, all this additional exterior people that are looking at this. So for me, naturally, if we were ever to have this and it was a malicious event, we would naturally reach out to law enforcement to make certain that we've got all of our ducks in a row, that we've captured all the evidence, we have a chain of custody is preserved, so that should we or a customer ever need to go to trial or to the courts, they have a preserved set of evidence ready for them with a timeline, with that we can clearly identify. This is interesting because in a data breach, back up, everything that we do in general is about limiting people's access to the data, to protecting the data, and to pseudonymization, where we don't want to know what it is, right? Data breaches are the one time, security incidents in general, are the one time where we actually try to undo that de-identification, where we actually want to identify a very specific individual or group of actors, and that's actually data privacy sometimes makes that very difficult to do because we've intentionally hidden this. We've intentionally had people delete their accounts. We've, all these other things, right? So it's a very interesting balance. I said this was straightforward, but apparently it's not.
And Erika, what do you think about the whole, potential data breach investigation?
Yeah, I agree with Joey, and I think a point he made, about in client contracts there is the big audit clause that we are able to be audited yearly, and also in the event of a data breach. I think it's important. Preparation really is just important, having all the right processes, procedures in place to be able to follow when stakes are high. Everyone, all hands on deck, everyone knows what they should be doing. And then I also think documentation in case of an audit, but also to be able to look back on. So I think something that's important that Platform does is, if there ever is a security incident or there ever were to be a breach, having a after the fact meeting, right, where you can refer to all this documentation, you can refer to the timeline of events, you can talk about how do we prevent this in the future, what went too slowly, where were there gaps in our process, how did we handle it, what can we do better going forward.
But I agree with you. And let me now take you to the last question in our session today. And I'll start with Erika and move to Joey. How do you treat data privacy security in an M&A deal? Is it a deal breaker, or can you live with it?
Yeah, so I think the most important part when you're dealing with an M&A is having a dedicated team and counsel that understands privacy, because during most mergers, companies are primarily concerned with the business and finance aspects, logistics, and what assets are being acquired. So it really is important to have a subject matter expert, a team of it, concentrating on privacy and data protection, and looking at the impact that a merger or acquisition will have. I think the most important part would be due diligence. So due diligence of the target company you're acquiring is absolutely necessary. And the best way to do this is using your company's current program and standards as a baseline and comparing the target company, looking into what they have. So for example, if you're like us and you comply with GDPR as your strictest privacy regulation, you can break down those elements into a due diligence questionnaire. You can have those aspects and requirements that make up your compliance privacy program and ask questions, get documentation, gain as much knowledge on the target company's privacy or lack of is extremely important. And you want to know before you go into the acquisition or the merger, what risks you're taking on, where the company has gaps. And as for it being a deal breaker, like as privacy counsel, we aren't making the ultimate decision on, are we going to go through with this merger or acquisition? But we are able to assess and give the business recommendations, let the business know where are we seeing gaps. I think we're also looking at whether the company has a strong security program, because maybe they're SOC 2 certified and they have all these security measures in place, but they're lacking in some privacy topics and areas. So when this happens, I think not necessarily a deal breaker, but it does require a deeper investigation and analysis. And you'll be asking internally the questions, okay, can these gaps be remediated? How much time and resources is it going to take our company to address these gaps? Can we use our existing procedures and speed this along, or are we starting from scratch?
And Joey, I'll let you conclude on this question, but then also add, how do you advocate in the M&A deal to make sure that privacy is at the forefront of at least the executive summary that the decision makers are making?
Yeah, this is interesting. 100% to everything that Erika said. She's been really good on the M&As that we've done. Erika's taken the lead for that. She actually wrote the M&A process for us, so she knows what she's talking about. The thing that I've seen, Erika's seen it too. When we look at other companies, what they traditionally fail at is what Erika mentioned, the due diligence. When you're going through an M&A, they'll bring in potentially an external counsel to help, an M&A expert. They may use an internal counsel like a GC, but many times they don't make use of what they have, which is a privacy counsel. And the privacy counsel needs to be involved in that due diligence process, so that if the privacy counsel goes through and finds out that there are significant gaps in there, the privacy counsel can then recommend to the business, hey, listen, they don't have DPAs, they don't have SECs, their GDPR compliance is not correct, etc. They don't have good security measures. What that allows the business to do is add that to the term sheet before it's signed. And so when the deal comes in, they sign that, yes, within a certain period of time, 6 months, 12 months before people get their payout, that you must now meet all of these requirements. You must have a good GDPR program. Maybe it's industry certifications like a PCI or SOC 2 or Sectum Cloud or HDS. And that's really the way to do it, because it focuses the attention, right? When you sign that term sheet, everyone's goal at that point on the receiving end that's going to get paid, they're going to look and they're going to try to get that list of items done as soon as possible, because that's when they know they're going to get paid. And so it's really important that we identify this material up front, get it in. One thing that Erika didn't mention that she does now is that when we look at M&As, we go off and say, listen, if you don't have it, before we even get to the term sheet, you're going to need to you need to go figure out all these vendors and get DPAs and do it, because I don't even want to talk to you. Right? Now, when you step back, the original question was, is it a deal breaker? And as much as I'd like to say yes, it's not, right? Because privacy in the larger business realm, privacy is only one component of it. And the way that I tend to explain it is when you're going to go buy a house, right? When you go buy a house and you go and you have an inspection done in your house, and the inspector says, well, the roof's leaking and it needs a new heater and it needs a new air conditioner, right? What do? Well, I still kind of want the house, but it has these problems, so I'm going to take money off the top. I'm not going to pay as much. So when you have these discoveries, so if you're an M&A, if you plan to get bought, here's a tip: make sure you have all this privacy stuff done, because then you're going to be able to get top dollar for your M&A. Because if you don't, people are going to come in and say, well, you have to do this and you have to do this, and not only are they potentially not going to pay you as much, they're also going to add it to your term sheet, so you're not going to get paid for it. So, these are the pieces. People are going to buy, companies are going to buy other companies regardless, and it's all about it's about the capitalism, that commercial sale. How are they going to get it done, and as Erika said earlier, what is the risks? And it's all